Very warm good evening to all. Namaskar. Today's topic is one of the very interesting topic. Those are in the legal practice of the criminal trial. In criminal trial, there are many judicial pronouncements which speaks about the last in theory. As the legal terminology suggests, last in theory means the lastly who has seen the accused and the deceased. Now we have to remember in these matters that there are always one person who is dead. That is why the word used is last in theory. When we speak that is last in theory, that means the accused and the deceased were together at the last time, and it is the duty of the survivor, that is accused or the any witness, to say how that person expired, how that person got injury and he was murdered, or what happened to him. This is what the last in theory. Now when we speak about last in theory, it is whether the person who is alive and one of them is deceased, then the person who is alive has to give evidence in the court of law and give the explanation to the police authorities that how what has happened actually and how the death occurred. Now the gap between the last in theory, that is between the accused and the deceased, if they are separated and something happens to deceased, the duty lies upon the person who is alive to say actually what has taken place. So the time gap between should be very less, and on also it is the onus, or I would say the burden of proof lies on the person who is alive. Now, when we speak about the burden of proof, we have to go to the section 106 of Indian Evidence Act. Now, this is an exception. Normally, burden of proof, who person who asserts before the court that this is in his knowledge he has to have. Now, here in the under section 106 of Indian Evidence Act, we have to see that the burden will lie on the person who says that this person was with me, and if he says that he was not available, or he how they have separated, it is their duty to explain to the police authorities and also in the court of law. So burden of proof under section 1 of Indian evidence is one of the important section which comes into play. So last in theory is one of the important part in any criminal trial when there is a death of one person and one person is alive. Now, normally, what happens in matrimonial disputes, if the husband and wife are in one room, and the wife something happens to wife, it is the husband who has to explain that the something has happened to wife, and he has to give the evidence that how the death has occurred. Now we will see many judgments where it will be uh, that the death has occurred and the I would say needle has pointed towards the person who was lastly seen with that person. There are many judgments in this regard. One of the judgment we'll share now. This is the Supreme Court judgment of Raman and others by state of Himachal Pradesh. Now here, the wife was a teacher. She always used to be at her father's place, and that was a point of dispute between the husband and wife. Now, what has happened? That always there was some letters also written by the husband that you come here and this is the last chance. And these letters are also later produced in the court of law. Now, when these letters were produced, and also when the wife disappeared suddenly, the father of the wife, he made a police complaint that there is some suspicion. Now, there was a this their home was near the Satluj River, and the accused have planted one footwear, also one salwar, to show that she has committed suicide. Uh, But it was not so. The father was confident that there's something must have happened, so he lodged a police complaint. Now, when this matter went ahead in the trial, there was also one paranda in the during the investigation. Paranda means something is tied to the hairs, which was also recovered. And after some time, the dead body of the wife was recovered from the Satluj River. And the dead body in such a bad decomposed condition that it was next to impossible whether to find out whether the dead body is of a woman or man. Only there was this one burnt mark which the father identified, and that is how it came to the knowledge that this is the uh, death body of that particular lady. Now the matter went into trial, and the defense was taken that because death body is not available, and dead body, it is not possible to find out whether it is of man or woman. Also, one of the defense was taken that dead body is of the child, 10 years old, because dead body was totally decomposed and eaten by dogs and all that. So it was actually very difficult to find out. But the court took the cognizance of the same, and they convicted the Ramanand and the family. And this is how, so this is the last in three. The court was completely uh, adamant on the last in theory that when a wife who was actually there in the house and she has gone in the morning to ease herself, and if she has not come back and she was lastly seen by the with the husband, it was his duty to explain. The burden of proof was on, because the prosecution has laid a there was a salwar, there was a footwear which were found there. There was a decomposed body, and they were saying it was a suicide case. But when her paranda was found in the jungle nearby, uh, and also when they have planted this salwar and the footwear to just to show that she has committed suicide, it was not believed by the court, and they were convicted by court. So this is one of the case where last in theory came into the play, and the accused were convicted. So in last in theory, mostly there are murder cases, because it is the word itself is used is the terminology last in theory. So lastly, who was the person who was there available with that person who was deceased. So this is one more case which is very important here. Now we go to another case of the Madras High Court. This is a case of se- uh, child abuse. Sexual assault was done on the child. Now here, this is pronounced by the Justice S. Vimla, written very beautifully, and with lot we can see the pain of the judge when we read this judgment. I may read the opening paragraph for you. Not all scars show, not all wounds heal, not all illness can be seen, not all pain is obvious. Remember this before passing judgment on another. So said David Avocado Wolfe. This code applies not only while judging the accused, but also while judging the plight of the victim. If we take into account the innocence, ignorance, and inexpressiveness of child, that is why it is said, silent and listen are words spelled with the same letter. But for listening that silent cry of the child, justice would be an impossibility. This is the more true in the case of child sexual abuse, which itself is silent crime. Here, the parents have gone to the market after leaving the child. She was playing. Now, this accused took the child to his room. He sexually assaulted the child and thereafter burned the child to the body in such a way that the complete evidence can be disappeared. Now, when the parents came back, they were trying to find out. Even the accused also was trying to help them, just to show that he is also concerned for the child. And this way it was going on. Somehow, one video was there nearby temple, and from that CCTV they can find out this was the person, the accused was the person who has taken the child. And there was also one more witness, PW3, whose evidence was very important in this matter. Now when this person was arrested, he also claimed innocence, but which was not true, obviously, because of the reason there was enough evidence. Now he has burnt the child with the petrol. Now normally with credit card, a person buys the petrol which he will put in the car. But here what happened? He has purchased the petrol, but in bottle. So that was one thing, evidence which was very important here.
Mobile network.
Yes, somebody is speaking. So the credit card entry for buying the petrol in bottles was pointing towards his crime. Also, here one person, PW3, when he went to the police station, he did say that I saw the accused was taking the child with him. That this was like last scene theory. Now, when here the last scene theory came, it was for him to explain that he was not there with the child. Now, this here those who are trial court lawyer, it is very important for us to understand that how his statement was useful to convict him. The prosecution has, now I'm reading the paragraph 43, the prosecution led in the evidence of PW3, who deposed on the day of occurrence while he was going upstairs to take back the dried clothes. He saw the accused, his dog, and a deceased, that is daughter, playing together in the second floor at about 6:15 p.m. According to prosecution PW3, was the person who saw the deceased in the company of accused lastly. Now, if we read further, it is the contention of the learned counsel for the accused that the initial statement of PW3 recorded under section 161 of CRPC did not disclose PW3 seeing the accused in the company of deceased, but only in the later statement, which was recorded after a period of 2 months. Now, when the statement is recorded before police, it is under section 161 CRPC, which is not signed. Now, the court came to the conclusion that the statement which is recorded before police is not on oath. It is not subject to cross examination. But what he has said before the court, that is PW3, that he saw the accused and the deceased together, is important substantive piece of evidence. And this piece of evidence was taken into account while convicting the accused. And in this matter, Justice Vimla convicted the accused for capital punishment. Now, one more thing I would like to add here. Whenever a session judge convicts the accused and give capital punishment, it is subject to the confirmation by the High Court. So, whenever the session judge convicts the accused, he or she, the judge, makes a reference to the High Court, which is called a criminal reference. So, whenever a capital punishment is given, this criminal reference will be before High Court. So, automatically there will be a confirmation by the High Court. And if there is an appeal by the accused, both will be heard simultaneously, and it will be a judge who will decide the fate of the case. Now, one more case I would like to share with you, all of you. This is the case from Delhi. Mostly everybody knows. Nupur Talwar was sister of UP. Mostly unfamously known as the Aarushi murder case, double murder case. Now, in this case, everybody knows the situation. There was 4 people inside the home, and Aarushi was murdered, and also the male help, Hemraj, who was there, he was also murdered. Now, there were only 4 people, and last in theory was actually uh, many times came into picture in this matter while the trial was going on, that these 2 persons, the mother and father, need to explain how 2 people were murdered when there were 4 people. So burden was lying on them. Trial court convicted them, but when the matter came to the Allahabad High Court, they were acquitted. Now CBI has filed the appeal against this judgment before the Supreme Court, which is pending. So we can't say much about that because there are outcome we are waiting. But very important part is this is one case where there were 4 people behind in the premises of the home, and when these 4 people are there, it is very important. They are the only person who can explain what actually has happened. So it is the facts which are in the knowledge of the person who was actually last seen alive with the disease. This is what the, I would say, complete substance of the last seen theory. There is one more case, which is also unfamous case from Delhi, actually from UP Ghaziabad. Later, the matter was transferred to the Delhi. Nitish Katara case, known as in this matter, I would say the mother of the deceased fought a lot for this case to bring the accused to the for to get them conviction. This is Vishal Yadav and versus state of UP. Now, this is a case which runs into, I would say, more than 500 pages, 538 pages. If you read this one judgment, I would say you will know the complete nonsense of the no, I would say complete the I will say small things about the criminal trial. Uh, Sir Ramjetmai sir was the accused advocate. He has taken the plea of the double hearsay, which I have rarely read. In this matter, I have read it. Now, when you say here, there was a this Bharti was the Vishal accused sister was in love with the Nitish Katara. Now, what happened when this they were about to marry and they had gone to attend a friend's marriage. Now, when they were attending marriage, Vishal Yadav and Vikas Yadav, the brothers of the Bharti, came there and they took the Nitesh out from there. And thereafter, he was not seen anywhere. So here again, the last scene theory came into play. And when this theory came into play, it was their duty, it was a duty cast upon them to explain where is Nitesh. Now, lot of things happen. Uh, Here, the police complaint was done. Even the charge sheet was filed, which was no much investigation was done. It is said in the came in newspaper that only 4 or 5 pages charge sheet was filed. So the matter went up to Supreme Court. Nitesh mother, she took the Neelam Katara, she took the matter to the Supreme Court and the proper investigation for proper investigation. And the matter was actually transferred to the Delhi, where the Delhi High Court later on, after the trial court, appeal was done to Delhi High Court. Delhi High Court Justice Geeta Mittal gave the judgment, and they were convicted for 25 years, which was also confirmed by the Supreme Court. Now, in this matter, if you see, there are double hearsay evidence, and also there are many aspects of criminal trial which is discussed. It is most important judgment from the criminal practice. Those who want to do criminal practice and understand this was the nonsense of the uh, criminal practice, it is very important that you read this complete judgment. It will take 2 3 days for you to go through it, but it is worth, because the way it is dealt and the way the judgment is written will teach you a lot of things. Now, one more judgment I would like to share with you. This is also a very milestone judgment in the criminal practice. Sharad Birdichan Sarda versus State of Maharashtra. Here, it's a matrimonial dispute. Here, the wife hardly stayed for few months with the husband, and she is to write letters to her, here also to her sister, where she is to say that she has become become a maid servant here, and she feels not at home at the matrimonial house. Here, one night after coming from the her parents' place, when she and her husband was there, she it is said that she has committed suicide, and there was a two doctors were called. Both these doctors said that it is an accidental death, so report it to the police, and the body was sent to for postmortem. When the body of the Manju Shri, who expired here, it was sent, it was found that she has taken a poison. There was a poison in her body. So thereafter, a complaint was lodged, and it was said that the accused has murdered her. And also, there was a complaint against the father of the main accused, their husband, and also the uncle. That before the trial court, all were convicted, and the matter went in appeal before the Bombay High Court. In the Bombay High Court, the both the accused, uh, that is the father and the uncle, they were acquitted of the charges, but his appeal was dismissed. The husband's appeal was dismissed. Now, matter came before the Supreme Court. In Supreme Court, the way it was argued that Section 32 was also here. The dying declaration. There were some letters written by her to her sister. Now here she was saying it is difficult to leave now. There was many things in that. But it was not immediate just before the death. That was not a cause of death. So section 32 was not actually acted upon. Thereafter, then last in theory again that it was the husband who was there. But the later shown by the defense that she was having some psychological problem and she was depressed. That is why she may have committed a suicide. And there are 2 points here, like an Arushi's matter, possibility that burden of proof lies on the husband, but there is a possibility because she was depressed, she may have committed suicide. And because of this, there was a doubt whether actually the husband has administered the poison or not. And because of this doubtfulness, the husband was acquitted of charges from the Supreme Court. This judgment is one of the milestones as judgment, and it has been referred by more than 3,000 if you check the internet. So I would say this is also one of the judgment which should be read, those who are into regular criminal practice. I came one more judgment while doing research, which is on also on last in theory, but it is of a district court from Tisajari, Delhi. Let me see whether I can share that. There was one important part in that judgment. I'm unable to find that judgment here. It was about a video. It was about a video footage. When these people entered the premises, there was a video, and the court says the video is one of the good witness video or any photograph because it will never lie. So video is not a witness as a being a last in theory, but the technology has taken so much ahead advancement that we can use that. So it is always useful if we can bring the video footage also, because in one of the first case which I have referred today, it was about the having the in the Vimla, Justice Vimla's case, there was a videography by the CCTV footage of that girl. The person was taking that girl, deceased girl, small girl. So that came. So this will lead to a conclusion actually who was there with the last in theory. So in this judgment, it was said that the video, the photographs are also one of the good witnesses if you can bring them to the books of the criminal investigation. So that was all about last in theory. If any question, let me know. As an advocate, what would be the defense against last in theory? Sumit, to now Sumit, good question. The defense is actually very difficult if you can't